Any facts that you think a jury could determine here or should determine in this kind of case, in an attacking case?
No, Your Honor. I think the whole inquiry should appropriately be submitted to a judge. If a judge thought that there were particular things that would be useful as advisory questions, I think it could be submitted. But I think in the usual case, a judge would make.
How is the judge supposed to know that what a consumer's impression would be?
Well, you know, I think
generally, just to figure it out. Well, some evidence would have to be presented to him or her, right?
It's possible, but I think that's similar to how a judge in the context of claim construction would understand what one skilled in the art would to be. They would look at the relevant considerations, they would put themselves into that frame of mind, and then they would make the appropriate determination based on all of the relevant factors. And in making that determination.
Thank you, Mr. Chief Justice, and may it please the Court. Congress designed the Trademark Registry as a relatively low-cost signaling mechanism to provide notice, but Congress made clear that the main event, the conclusive determination of the right to use a mark in commerce, was reserved to Article III courts with robust procedures and sweeping remedies.
But you do have that alternative after a board action.
We certainly do with respect to district court review. It's de novo, and that's one reason, Justice Sotomayor, why we think when we're analyzing whether Congress intended to adopt a preclusion doctrine, we think the answer to that is no.
That's my problem, which is it seems to me that you're rendering the board proceeding almost irrelevant with respect to litigation.
Yeah.
And it may be when you're seeking de novo review, but why should we say that you get a second bite at the apple after you've wasted the board's time? Why not just tell you go straight if you're going to wait for an infringement action, go there?
Right. Well, I think that
Yes, Justice Ginsburg, I'll address that. But first I'd like to say that I think a key point here is that if the inducer is right that the patent is invalid or that it's not infringed, he will not be liable because the court will find that the patent was invalid or not infringed. And so in that case, you don't have to worry about liability. So the question is really what should happen when the defendant is wrong, right? Who should bear the risk of the defendants being wrong that the patent is invalid or not infringed? And we think the inducer should bear the burden. This is someone who knows about the patent, who has considered it, who has decided not to challenge, not to use the statutory mechanisms that Congress has provided to challenge the patent.
The patentee has a cause of action against the person who violates the patent, right? You're just talking about supplemental liability for somebody who induced that violation. And generally for that kind of liability, we have required mens rea. We have required knowledge that you're doing something wrong.
Well, 2 points with respect to that. The first point is that certainly in the criminal law, you may need wrongful intent when you're an aider and abetter, but you do not need knowledge that the principal offense is illegal. So, for instance, if you're aiding and abetting a felon to possess a gun, you need to know that you're selling them a gun and that they're a felon. You don't need to know that it's illegal for a felon to possess a gun. So we think that's analogous here. The second point I would make is that 271B is not simply supplemental liability. It is an important means of enforcing
And I'll tell you, in my example, the price and output is a big payment to the owner of the patent in year 29. That's the price and output. And the output is restricted because the price is up.
So, but during the term, the licensees got to use the invention
there are a lot of good reasons for it. My simple question was how you reconcile the fact that everybody is paying a lot of money to use this intellectual property in year 29 with what seems a statute and a constitution that say it should be free at that time. That's what I'm asking. I don't want to ask it again because I don't like to ask a question more than 4 times.
I apologize if I have not been clear in my answer. Let me take another shot at this. The answer to your question is that one needs to, in our view, is that one needs to decouple the right to exclude, which is what the term is about, from the royalty arrangement. Understanding
by that.
I just want to make sure I understand your answer to what the gap is between a certain kind of fact and then the ultimate question of law. So when an expert gets on the stand and gives testimony about what a person in the field, a skilled artisan in the field, would understand to be the meaning of a particular patent term, and you're saying that that's factual and that the decision whether to credit that or not is a factual determination. But how is that different from the ultimate legal question that the court has to answer, which is kind of the same thing? It's how a person, a skilled artisan in the field, what that person would understand the patent to mean.
Well, the difference is that the instances, and there will be frequent, where it's not kind of the same thing. And let me spell that out. So the first part of your question is what the expert says factual, the meaning to skilled artisans? And it absolutely is, just as it is in this Court's contract and tariff cases, where the Court specifically says that the meaning of a term to people in a particular field to which the judge doesn't belong, that's a fact question, and so is whether there is a specialized meaning. But where there is no specialized meaning, or any specialized meaning is irrelevant because the patent itself, through the process of document construction, tells you what the answer is. So, for example, here's the ordinary meaning of this term, but that won't work in the context of this patent because it would run up against the canon of claim differentiation. That won't work in this patent because it would make the invention not work. That wouldn't work in this patent because then the preferred embodiment in the specification wouldn't be encompassed.
So what you're saying is that in certain cases the factual finding truly is the legal determination, but that in other cases other matters can come in to drive a wedge between the two.
Correct. And I think that